of applause for the celebrity. Thank you, everyone. Now, we take this opportunity to honor and facilitate distinguished guests who have graced us with their presence. I request Vice Chancellor Ma'am Kim Meneses to kindly felicitate Honorable Mr. Justice Mustaq, Judge, Kerala High Court. Let us have a huge round of applause. I now request Ma'am to felicitate Honorable Mr. Justice B.P. Singh, former Judge, Supreme Court of India. Thank you, ma'am. I now request Dr. Jairam Raghunath, Dean, School of Law, to felicitate Dr. Lalit Bhasan, President, Society of Indian Law Firms. Let's continue with a huge round of applause. I now request Sir to kindly felicitate Mr. Anil Xavier, President, IIAM. The felicitation will surely be incomplete without honoring our esteemed judges for the final round. I request Dean Sir to kindly felicitate Mr. Ratan K. Singh. Let's continue with the huge round of applause. I request sir to now honor Mr. Rajesh Jha. I request sir to now felicitate Ms. Iram Majid. I now request sir to kindly felicitate Advocate Anand Kaushik. Thank you so much, sir. To officially mark the beginning of today's proceedings, I now invite Dr. Jairam Raghunath, Dean, School of Law, Goenka University, to deliver his welcome address.
So good evening, everyone. Honorable Justice K. Minister, Honorable Justice B.P. Singh, Honorable Dr. Lillian Person, sir, Mr. Xavier, esteemed judges of the final event, along with Mr. Ratan Singh, Mr. Rajesh Shah, Mr. Ramanjit, and Mr. Anil Kaushik. It's my proud privilege to extend a warm welcome to all of you. Dear faculty members, distinguished guests, all are present here. A warm welcome to all of you. Now that we have come to the third day, that is the concluding day of CR International Moot Court Competition. 3 days of extensive deliberations on the moot problems. I really got a positive feedback about the events, the threadbare analysis, probably one of the most challenging events for the judges to take a final call. So the event really went well. So we have reached the final stage of this event, valedictory and the prize announcement. This is setting a new beginning for another major initiative by School of Law, Goenka University. We are establishing a Center for Conflict Resolution. I'll briefly explain the concept of Center for Conflict Resolution. It is being conceived as one of the dispute resolution center, which is normally an area center which establishes in most of the law school. What makes it different from other institutions this is going to handle a proper dispute resolution within the campus. The center will equip all the students and faculty members, train them, and be a part of the dispensation of justice through actively making them involved in arbitration process. Along with that, we are also initiating mediation trainings as well. Probably that also will be materialized soon. So with that note, I think since the talk is quite long, I will directly come to my assigned role of welcoming the guests. I'm really thankful to Justice Mushtaq. We flew down all the way from Kerala to judge this competition and to be with us to encourage and motivate the students and the entire team. Thank you very much, sir, for joining us, and I extend the most cordial welcome to sir. I'm usually interested to this is V.P. Singh. He has agreed to join us on a short notice. I'm really thankful to you, sir, for gracing this occasion. I'm very welcome to you. Dr. Yanil Basin, and I don't think we require an explanation to what his contributions are. The 7th Goenka that we are celebrating now is the result of this collaboration and his support and his mentoring. And I'm really thankful for the day one. I joined, I just wanted to make this event into a physical mode, and it has been materialized with the absolute support of Dr. Lalit Basin, sir. Thank you so much. And I think you are the host. For the purpose of formality, I extend a warm cordial welcome to you, sir. And Mr. Anil Xavier, he is, we've been associated for quite long from my previous institution, and he has come up with an extremely different idea of establishing dispute resolution centers in the campus, which actually is going to redefine the landscape of legal education. So it's a paradigm shift. Perhaps this is going to be one of the unique initiatives that is going to happen in any law school, and I'm happy that we are leading that as a member of the committee. I mean, I'm really happy, and Xavier has come down all the way from Tripoli again to be a part of this inaugural function of the Center for Conflict Resolution. Thank you so much, and I extend a warm welcome to you. And our key judges for the finalists, Mr. Jatin K. Singh, thank you so much, sir. I was enjoying I'm sorry for the delay in joining you, because I was enjoying the interaction in the courtroom. Somehow I just actually wanted to come out, but the interaction was so warm and so challenging for the students. I saw students losing their cool at one point of time, but again, it's a part of the exercise. Thank you, sir, for joining us. Mr. Rajesh Shah, of course, I know Mr. Guru is heading Southeast Asia. Warm welcome to you, sir, Prakesh, and thank you for joining us, and warm welcome. Of course, she's been a part of the whole Center for Conflict Resolution at Manipur and here, and now she's going to lead another initiative here. She probably might join us a mentor for our center. Of course, we are looking forward to your guidance and support. Warm welcome, and Mr. Anil Kaushik, sir, again, thanks to you for joining us. Again, on a short notice, Satna had given a call. Thank you for joining us. It was a wonderful session. I really enjoyed. And finally, the team. You've done an amazing job, and you made your arguments and contentions really challenging for the jurors. I mean, judges. Every time in the prelims, when I used to interact with judges, they were actually happy that the students have taken mooting really serious, and that has actually resulted, and probably this will improve the importance of the mooting further, especially in arbitration moot. And one thing I would like to share with you, mooting is not about winning a case, it's about winning the heart of the judge. And probably this is one advice I would like to share with you. Maintain your composure, never lose your cool. Judges might trouble you like anything, they are meant to do that. Of course, maintain your composure, take it on a good note, slap a smile on your face and face it. Thank you, and wish the winner all the best. I mean, you just won because of a small margin of a positive thing that you have done in front of the judge, and you made it to the final. And from final also, the one who won has impressed the judge. Okay, that's the outcome. Thank you so much, and let's
Thank you so much, sir, for your valuable insights. It is my privilege to now invite Dr. Kim Meresis, Vice Chancellor GD Goenka University, for her presidential address. Ma'am continues to shape the future of learning at GD Goenka University and beyond. Welcome, ma'am.
Good afternoon. I don't think I'm going to take too much time because I think Jairam has stolen all my words, and taken all my time. So, welcome to GD Goenka University. I think welcome Justice Mohammad Mr. Honorable Justice E.P. Singh, Mr. Anil Xavier, and Dr. Lalit Basin for taking time and being a part of this event. We have been working with Dr. Lalit Basin for lots of years, and I had the privilege of working with him personally as well. So thank you so much. I think over the past 3 days, we have witnessed an extraordinary demonstration of legal acumen, advocacy, and intellectual rigor from our talented law students from across the country. And I think you're dying to go back. So I think we're going to keep this short so you all know who the winners are. And you have 3 more speeches after me, I think 4 more, so let's keep this short. I extend again my heartiest congratulations to every one of you for being a part of this moot court competition. I urge you all to take forward the key learnings from this competition and continue striving for excellence in the legal domain. Arbitration is not just a subject of study, but it is a powerful tool for ensuring justice, efficiency, and global cooperation in resolving disputes outside the court. So thank you very much once again, and I think I look forward to all the dignitaries on the dais giving their speeches so we can have some learned discussions. Thank you so much.
Thank you, ma'am. Today, we have the honor of hearing from some of the most distinguished figures in the legal fraternity, each of who has made remarkable contributions in the field of law and justice. To begin with, Mr. Anand Xavier serves as the President of Indian Institute of Arbitration and Mediation and the Chairman of the APGAM. He also serves as the Vice President for the India International ADR Association and is an Executive Committee member of the ADR Law Section of the Indian National Bar Association. He is empaneled as an international accredited mediator with several esteemed organizations including Singapore International Mediation Center, Florence International Mediation Center, Italy, and the ADGM Arbitration Center, Abu Dhabi, UAE. He also serves as a senior mediation expert with the Mainland Hong Kong Joint Mediation Center and the Japan International Mediation Center in Kyoto. Along with this, he is a designated senior advocate at the Kerala High Court. I request, sir, to please deliver your speech, and I request everyone in the audience to join us for the warm welcome.
Thank you so much. This is Mr. Justice V.D. Singh, Dr. Kim, Vice Chancellor, Dr. Lilith Larson, Dr. Jairam, of course Mr. Ratan Singh has left, Mr. Jha, Mr. Ram, and Senior Advocate Mr. Anil Kaushik, the learned faculty members of GD Goenka, and dear friends. See, as law students, one of the prime considerations that we all should have is considering the people's access to justice. Because ultimately, it is justice that matters. Because even after the moot competition, we were discussing about access to justice. And the common perception of access to justice is to think that a person who has got a grievance has got an access to an institution to put forward a grievance, to put forward a complaint, and to get access to that, or for the other side to take their defense before that institution and get a decision on that. But we know the delay in access to justice, the difficulty in access to justice has actually deprived many people who are staying in different locations, who are underprivileged, who are not able to get proper access to justice. So when you look at the concept of a welfare state, the concept of justice has evolved. The access to justice now is mostly concerned or considered as an access to effective justice. It is not just access to justice, but it should be access to effective justice. And there are many concerns and considerations that happens when you talk about access to effective justice, because it's always easy to talk in a speech that access to justice or access to effective justice can be a thing in this manner. But putting it in a practical scenario, it becomes difficult. And it's a good thing that GD Goenka College is inaugurating the Center for Conflict Resolution, especially concentrating on arbitration and mediation on a day when the finals of our international arbitration moot competition is happening. Because if you look at evolution, the students who are trained in moot competitions are actually arguing matters or looking at cases on a conceptual note. When a moot problem is given and they are deciding or they are arguing the matter on that moot issue. But taking to the next step, because very rarely, if you look at lawyers who are just enrolled or who have just started their practice, see, we don't find even young lawyers up to the experience of maybe 10 years or 15 years who will be dealing with arbitration matters, sitting as arbitrators or dealing with arbitration cases with live clients and live cases. So considering the enormous requirement of providing provisions for access to justice and also training young lawyers to get into the field of arbitration and mediation, because that, of course, I consider that this is the future of justice delivery mechanisms, because litigation will always, I know, sitting judges and retired judges are sitting here, but what I feel is litigation should have or should be the last resort, not the first resort, where you should go for access to justice. Access to justice should begin with negotiation, should go to the next level of mediation, and then to a binding mechanism of arbitration if that is possible, and if not, going to litigation, because that is the last resort a person can look at. So considering this situation, we thought, see, when medical colleges have medical college hospitals, why not law schools can have justice delivery centers in the law schools itself, where law students can manage that centers, law students can administer those centers, and law students can deliver justice in those centers for real problem, for real people. That is why this concept of Gateway to Justice was launched on 1st of December 2024 by Justice Suryagan, Judge of the Supreme Court. And we conceived a concept of establishing justice delivery centers in law schools, where law schools will not be just imparting legal education, but also will be serving as justice delivery centers. So it's a composite package where you will be, along with learning the law, learning the process of adjudication, you will also be imparting justice delivery in law schools. So how do you do that? Because sitting in a law school, many people may not approach you directly. So that is why this concept of establishing an area center where you can do offline and online arbitrations and mediations with trained and accredited arbitrators and mediators within the law school itself. But definitely the clients will have a question mark when they find that the arbitrators are law students. So you need a level of security or level of scrutiny on those proceedings. So we have developed something which is an online or an ODR platform which can help you to do it if you are doing it in an online scenario, where you can sit in your college in a designated dispute resolution center, and the parties and the lawyers can appear before you through online platform. And you can do the process, of course after proper training and after proper accreditation, you can do the process through this online media platform which has got PeaceGate, which is AI powered and AI assisted, so that the entire process you are guided to do it in accordance with law, in accordance with established procedures and the formats. Of course, the decision making is ultimately the arbitrators, nobody can interfere with that. Now recently the UN has also come out with protocols where if you are doing any arbitrations with AI assistance, you have to declare as to what extent the AI is interfering in the process. So we have adhered to that. So the AI interference or the AI assistance will only be with respect to the procedures. It will not affect your decision-making capacity. But of course, there is one process that we have started. It's recently in 2021, the UN had come out with an expedited arbitration rules. But it's a very, very, what you call, supersonic arbitration that they have conceived, which is not practical at this point of time in India. So we have a little more expanded arbitration time frame. We have put an expedited arbitration rules which can complete the entire arbitration process within a period of 120 days. And there is a monetary limit that it can only arbitrate matters which are up to the limit of 35 lakhs, not beyond that. So this justice delivery centers in law schools will be primarily doing arbitration under the expedited arbitration rules. which does not require oral evidence. It will be purely on documentary evidence, and it will be by default online. Of course, you will have other arbitrations also, which will be conducted in the Justice Delivery Center in the college. And under the extrajudicial arbitration rules, you have a scrutiny mechanism where once you ultimately, when you make an award, the draft award will be submitted to the scrutiny board. The scrutiny board will comprise of senior, experienced arbitrators who will check your award, but will not interfere in your finding, but will point out if there are any procedural errors or any matters or any defects which can ultimately set aside that award in a court. So those defects will be cured by the scrutiny board, and they will give you the recommendations, and it's up to you as the arbitrator to accept or reject those recommendations, because ultimately the power of decision making is of the arbitrator. So it will come back, and probably every law school, like GD Goenka, there will be a in-house scrutiny board members who will be senior faculty members who will be having expertise in arbitration, and they will be checking your arbitration awards when you make the draft awards, and only after the scrutiny board checks it, you will be publishing the awards. And similarly, we will be, in the next stage, we will be also looking at making mediation also part of it, because you will be trained for mediation. That's what Professor Jairam said, that the mediation training also will be done. And the students who are interested in doing mediation will act as mediators, and they will be resolving matters which can be mediated. So now if you look at the progress, because even after the 1996 Act, the progress in arbitration was so fast after 2015, because there was an amendment in 2015, 2019, 2021, and now after the Mediation Act is made, when Part 3, conciliation is removed from Arbitration Act, now the new Arbitration Act is proposed, it will be coming very shortly, so it will be the Arbitration Act 2024. And so the progress of arbitration is, or the movement of arbitration is making a very strong progress. And one of the most important, the timing, because if you look at the positioning certain things, see, the time in which we do certain things are also important. Because now actually India is posed in a position where you require hundreds and thousands of arbitrators, because now recently the Supreme Court in one of the famous judgments called the court judgment, they have mentioned about unilateral appointment of arbitrators. And for the very first time, the Supreme Court has interfered with arbitration, which is purely a contractual matter, borrowing the principle of the Constitution, and held that unilateral appointments are violative of Article 14. And under the constitutional principles, they have quashed those awards or those proceedings entirely. So now we have a position where, if you look at Schedule 5 of the Arbitration Act, it says that an arbitrator cannot arbitrate more than 3 disputes of a particular company in a gap of 3 years. And also a law firm cannot appoint an arbitrator for more than 2 cases in 3 years. So you can now imagine how many arbitrators you require in India, considering the volume of work that India has. So now it's a time when you start building up your profession, who is interested in building up a profession in arbitration, to start your profession as arbitrators right in the law school itself. The advantage is, but as I said, it's all small state matters, but you will get the experience. And you also are not doing a free service, because you are acting as an arbitrator and you are entitled to get the fee for that. So while you learn, you also earn. So it's an opportunity for you to start earning when you are in law school. You start doing your arbitration and you proceed with that process. So the details of how it works and how the arbitration center will be working and how this Center for Conflict Resolution will be working, the college, the Dr. Jairam and the other faculty members who are in charge of it will explain to you. So whoever is interested, and of course I know there are law students from other law schools also. We have signed up with 6 law schools now, and 8 law schools now, and we'll be having more because the requirement is so huge, because India is what you call paced for a major arbitration growth. And as Jairam correctly pointed out, this will be a paradigm shift where justice delivery will be brought into the law school. Of course, it will be a great help and it will be a great support for the courts as well, because there will be a filtering of work, because once mediation also begins, there will be a first filtering of disputes in the law schools itself. Only then it will go on to courts and other dispute resolution centers. So this is the concept, and I hope this center will be a success, and we will produce at least some 100, 200 good arbitration lawyers and arbitrators in future in the legal profession from GD Goenka. Thank you so much.
Thank you so much, sir, for your insightful words and a true insight on access to justice and litigation being the last step of the justice and not the first step. It is now my immense privilege to introduce a towering figure in the Indian legal fraternity, Dr. Lalit Bhasi, a name synonymous with excellence, integrity, and leadership in the field of law. Welcome, sir.
Professor Dr. Kim Nandan, Vice Chancellor, Goenka University, Honorable Mr. Justice B.P. Singh, Honorable Mr. Justice A. Muhammad Mushtaq, Dr. Jairam Raghunath, Ms. Sania Kapoor Vadva, Ms. Shraddha Oberoi. I'm sorry I missed out Mr. Anil Zavia, President of Indian Institute of Arbitration and Mediation. But last but not the least, my dear young friends who have participated in this tournament. I really find it strange that we people who are on this side and you are on the other side, that we are being felicitated. I think you ought to have been felicitated, you the students who make these institutions work and the faculty members. I think you need to be felicitated, and on our own behalf, I felicitate all of you. We have done enough lip service to the cause of dispute resolution. What is the ground reality? I was sharing a head table with the then Honorable Chief Justice Chandrachud in Pune at the Symbiosis convocation, and the Honorable Chief Justice has highlighted the ease of filing cases online, evidence, affidavits, everything, even the virtual hearings which are taking place all over. So that is commendable. Then I was to give my concluding remark, and I said, Your Lordship is right, you have facilitated, but what about the disposal of the matters? Disposal, because of the ease of filing, is now multiplying. 2 years ago, we had 5 crore cases pending all over, and today we have more than 6 crore cases pending. So how has the technology or AI, how has it helped the citizens of this country who are looking for good, effective system of administration of justice? Are they getting justice? So that is the stage of litigation. What about arbitration? In my 63 years of experience as a lawyer, I can say with some conviction, with some sense of responsibility, that arbitration also has failed to take off in this country. Arbitration has become very expensive, very prolonged, and add to it the uncertainty, because the awards can be interfered with, and if they are interfered with and the matter goes to the courts, then it will take the next generation, you see, to get the verdict and all that. young students, I ask you, because along with your expertise that you get, as lawyers you have some responsibilities also. Responsibilities as a lawyers are inherent so far as our legal profession is concerned. Lawyers have played, I don't have to tell you what role they have played so far as our struggle for independence is concerned. What role they have played even after that, virtually giving up their lucrative law practices and serving the governments as ministers and all that. So you have a sense of responsibility also. I will ask you one question. Supposing you have become a lawyer. A client comes to you with his problems, his legal issues. You look into that. What is the first advice that you will give him? That is the beginning of your sense of responsibility as a lawyer. What is the advice that you will give to that client of yours? That firstly you have to tell him whether he has a good case or he has a bad case. That is firstly what you have to tell him, frankly. Because that is the relationship like between a doctor and a patient. Same relationship is there between a lawyer, you see, and a client. The client will share everything that he knows about the matter, but then the guidance is required from you. And the guidance is not, oh, this client has come, let me tell him that he's got a good case and I will fight it out in the court because that is how I will make money. That is not your responsibility as an ethical lawyer who believes in the nobility of this profession. We are still a profession and we should continue to be a noble profession. Therefore, the first and foremost responsibility is of a lawyer is to give advice. Second and most cardinal responsibility is, which has something to do with this 5 and 6 crore cases which are pending, is to try to settle the disputes. As has been rightly pointed out, it is mediation is the answer now. And that is where the role of the lawyers, whether they are eminent in-house lawyers like Mr. Rajesh Jha here, or you see eminent lawyer like Mr. Anil Kaushik, you see, who is sitting here. You see that trying to settle the disputes. And what I have been impressing upon the universities and the law schools, that try to develop among the students negotiating skills. That is very important. These moot courts are important to some extent, but along with moot courts, as I said earlier, because this is I think my 4th or 5th visit to this campus, that also encourage good legal writing. Legal writing is so important because the judges first read what you have filed before them, what comes before them. And if your legal writing, you see, is not clear, is vague, then God helps, you see the client. Then we have a culture of samjhauta, settlements, right from ancient times. The panchayat, what was it? It was not adversarial. There was a general consensus which was built up. Then we had Zilla Parishads, same thing applied. And during Mughal times also, we had Adle Jahangir. Adle means justice. The emphasis was always on justice, settlement of disputes, not you see to blame each other and you see to fight each other. It is only the British who brought this adversarial system, you see, in this country, which has played havoc, you see, with that. Therefore, but we are bound by it, because now we have a constitutional setup that can't be changed. The constitution is there which says that this will be our system of administration of justice. So within the framework of constitution, what is the answer? Answer is mediation. Because you don't need a law. You see, we have been talking about the mediation law and all that. You don't need a law to settle disputes. You need a change in the mindset of people. That it is not good for me. And as Lord Denning said about 50, 60 years ago, he says a bad settlement is better than successful litigation. A bad settlement. And Justice Krishna here said, when you win a case, that is very satisfying. But when you settle a case, it is divine. That is the Therefore, I appeal to all the young students here who will be budding lawyers or budding in-house lawyers, some fighting in courts, some doing corporate work. Always try to get the disputes settled. Only then this 6 crore will not become 10 crore, but possibly the number may go down. Thank you very much.
Thank you, sir, for inspiring our students to be responsible lawyers and trying to fill the gaps in the legal system. It is now an absolute honor to introduce a stalwart in the Indian judiciary, a jurist whose wisdom and dedication has left an indelible mark on our legal system, Honorable Justice Mr. B.P. Singh. With an illustrious career, he served as a judge of the Supreme Court of India from 2001 to 2007, delivering landmark judgments that strengthens the foundation of justice and constitutional values. In his judicial tenure was marked by profound rulings, including cases that reinforced criminal jurisprudence, constitutional interpretation, and administrative law. A visionary in the field of law, Justice Singh's legacy continues to inspire legal minds across nations. With great respect, let us extend a warm welcome to Honorable Mr. Justice B.P. Singh. Let us extend a warm welcome to Justice Singh.
My dear friends, this is not my first visit to this institution, perhaps it's the second one. Coming and meeting all of you, bright faces, hard-working people, young, energetic minds, does a lot of good to old people like me. We also start feeling young. And that's the feeling I get today. I'm so happy to be with you. You are today talking about the judicial system, the role of a lawyer, the accessibility to justice. All these sound very important. But what is the importance that we are giving to these judgments? Many of you will go and become lawyers tomorrow. Some of you will join the bar and be on the litigation side. Some of you may go for corporate law. Some of you may go for advisory. Now you have a lot of jobs which require trained lawyers. These things didn't exist at one time. At one time there were only 3 professions: lawyer, doctor, engineer, nothing else. No choice. But to join the profession is perhaps the easiest, legal profession I mean. But to succeed in the profession is the most difficult because it requires a lot of hard work. The legal profession is a very hard taskmaster. It spares no one. But then it has also its great moments of joy where you feel that you have achieved something. And the profession, as it existed some time back, is not exactly the same today. Let me tell you, the profession has changed its culture. It is not the same as it was, say, 50 years ago. Things have changed. Values have changed. There was a time when being a judge of a high court brought you respect. Being a member of the profession brought you respect. It was assumed that you are respectable, you are respectful. Today, you have to prove that you are respectful. Your merely being a judge means nothing unless you prove that you are a respectable person. Your being a lawyer means nothing unless you prove that you are worth respecting. The atmosphere in the courts has changed. I remember even when I joined the profession, if you entered a courtroom, you could hear only one voice. That was the voice either of the judge or of the lawyer arguing the matter. When a lawyer argued a matter, and he was arguing his case, there was hardly any interference by the other side. And when the judge spoke, the lawyer kept quiet, listened to the judge, thereafter answered the question. Today, and I think I am also one of those responsible for it, we find sometimes in the courtroom that everyone is talking and no one is listening to the other one. And ultimately, the whole atmosphere is such that it becomes difficult to do justice. A lawyer is arguing his matter, the other side, lawyer will get up and say, no, this is all wrong. Little realizing that he will also have a chance to reply to what he is saying. And the judge is trying to sort of, specify it and say, don't quarrel, please, let him argue. So these experiences are rather unfortunate. The first lesson that lawyer must learn before he enters the courtroom is to respect his opponent. Unless you do that, you can't have an enjoyable session in the court. And when we say respect your opponent, it does not mean that you accept whatever he says, but certainly there is some dignity even in dissent. Even among judges sometimes, they differ in their views. But then the difference is not expressed in language which is castigating the other person, but it is respectful, it is dignified. Therefore, in whatever you do as a professional, as a lawyer, as a judge, maintain the dignity of that office. Let it not appear to another person that they are just like us, they behave just like us. There was a time when, apart from learning that everyone has emphasized before you, knowledge of law, hard work, there was still some scope for wit and humor in court. That is unfortunately getting reduced nowadays. There is not humor inside the court, people are laughing at you outside the court. That's the unfortunate part. But I can tell you one or two anecdotes, because these things can happen in court today also. There was a lawyer who was arguing a matter, a second appeal, nothing much to be argued. But he was going on, and there was a British judge hearing him. The other side lawyer interfered and said, "My lord, there is nothing in this case that is necessarily wasting your time. He said, please sit down, you'll have your turn." And then he looked at his watch and said, "Mr. Counsel, how long will you take?" He said, 5 minutes more. All right. Went on and on. After 10 minutes, he again said, "How long more will you take?" He said, 2 minutes more. Went on and on. Ultimately, he finished. And the gentleman got up on the other side. He said, "I'll tell your lordship." He said, "Yes, come on, tell me." He started, and he wouldn't end. Went on and on and on and on. Then this judge asked him, "Mr. Counsel, how long will you take? And he said, I have noticed one thing, my lord. You're not looking at your watch. He said, no, not at all. So he said, so what? I'm looking at the calendar. So it can happen. Sometimes a little bit worse. Sometimes an advocate may take a hint and the judge is talking in court. Now, the subject which Mr. Prateen mentioned just now about what is the duty of the lawyer when a client comes to him with a case. There is a lot of wit here also. Some people say, will advise you, say, your duty is to tell your client what truthfully you feel about his case. To that extent, there is no disagreement. When a client comes to you, you must tell him honestly what you feel about his case. But thereafter, what happens? Supposing he says, no, doesn't matter, you find it. I'll take the chance. Some of you will say, no, you can say, no, sorry, I will not accept your brief because I don't find any merit in this brief. But someone will say, all right, if you're prepared to take this, do this. Now, who is right? Very difficult to decide. And I remember in one matter, when I got up to argue a matter, then in the Supreme Court, he looked at me and he reacted in a particular way. I was quite surprised. Then he said, Mr. Singh, are you surprised by what I have said? I said, no, my lord. He was saying something in my favor. So he said, no, you should not be surprised. I said, no, my lord, I am not at all surprised. I thought your lordship would react in this manner. I said, no. He said, no, you didn't. You thought you had no case. Let me advise you, you are a young lawyer. You take my advice. If a client comes to you, you tell him what his case is. Explain to him the good or weak points of the case. But if after you tell him that he has no merit in his case, he still insists that you file the case, please file it. That is your job. Your job is to bring him to justice. He says, I may have a bad case, but I'll take a chance. Give him that chance. Because you may be a very hard-working lawyer. You have read all the facts of the case. You have mastered the facts. You are a great lawyer. You have understood all the ramifications, the legal ramifications of this case. But there is one thing you don't know. What is that? That is the madness of the judge. So, in litigation is, in a sense, a type of gamble, where you may win, you may lose, whatever may happen, not depending upon the merit of the case. But I remember Mr. Daftari was once asked in the Supreme Court. The judge was very angry with the case, there was nothing in the case. So he looked at him and he said, Mr. Daftari, did you advise your client to file this case? He looked at the judge and he said, no, my lord, nowadays we don't do that. So what do you mean you don't do it? He said, my lord, it's so difficult to predict which side the cat will jump in this court. So, you see, these things happen. It will depend on each case, but I hold the view that if the client insists that he will take a chance before the court, I don't think you can tell him what you feel about his case, but then don't refuse to file his case and fight his case for what it is. Because I can tell you that, say out of 100 cases which I may have refused, 10 succeeded. That is what I came to know later. And once I was sitting in my chamber and Mr. Sirvai, very famous lawyer, he used to sometimes come to my chamber and said, we'll sit here and work. A client came and he wanted me to file his case. So I told him, I said, look, I've seen your papers. You're not a very rich man, you can't waste money. You have a family to look after. I will not advise you to file this case. But he persisted, insisted. I thought Mr. Sirvai doesn't know Hindi. but I didn't realize that he understood Hindi. So after I refused the brief, client went away. Then he asked me, he said, "BP, you refused the brief. I saw that you were talking to your client. Why?" I said, "Sir, there is nothing in this case." He said, "He had come to engage a lawyer, not a judge. Who are you to give an opinion? You should have given your opinion. But if he decided, he was insisting that you file this case, and you were insisting that you would not file this case, and ultimately you have sent him out." I said, "Yes, I thought that was the right thing to do." He said, "No, we have done no good to him. He will go to some other lawyer and he will file this case." So why get into all these things? Therefore, the view is quite divided on this issue of what is the duty of a lawyer towards his client. I would say one thing which is not disputed is that he must tell the client what he truly thinks about the merit of his case. Thereafter, leave the choice to the client. This duty to the client is one thing. Duty to the court is also something which has to be considered, because a lawyer is also an officer of the court. And as an officer of the court, he owes a duty to the court. And what is that duty? That duty is to place the case of his client correctly according to the record, argue in a way anything, but never misstate a fact, or never conceal a fact if it is on record. One thing I can tell the young lawyers, that there is nothing which makes your life more enjoyable at the bar than a feeling that the judge also respects you. If you earn the faith of the judges, your task becomes very easy. And therefore, not only should you know your client, not only should you know the merit of his case, you should also know the judge. Know the judge in the sense that you must know what are his likings, what are his dislikings. I have found from my own experience that if you have placed your case honestly before the court, the judges also get inclined to help you if they can. If it is a hopeless case, they can't do anything, but otherwise they would. Now let me talk about the pendency of cases. Very difficult to say who is to blame. Should we blame the government that 40% posts of High Court judges are lying vacant? Or where lying vacant? I don't know whether it is 50 or it is 30 today. Now, as it is, you have less number of judges. On that, top of that, you have vacancies. How do you expect the remaining judges to deal with the load of cases that they have? That's one. Two, you go to a magistrate's court, you will have a very long list of cases, maybe 100, maybe 150. So I asked once, why do we have such a long list? They said, "Sir, we can at best deal with about 7, 8, 10 cases in a day. But the other cases are put on the list, lest they may be forgotten in due course. Therefore, that rotation goes on. And people say, date padti hai, aap to hota nahi. This is correct. Date hi padti hai, at least only for that purpose it comes on the board." Third, where the bar is concerned, this adjournment rule, adjournment for nothing. I don't know why it is asked for, and I don't know why it is granted. Differs from case to case, judge to judge, lawyer to lawyer. I always thought that if there was one reason why disposal of cases is slow, it is on account of the feeling that the matter may get adjourned. Lawyer takes it easily. He tells his junior, "Arey, take the time. Adjournment level." All right. Judge grants the adjournment. So next time when there is a case, the judge might think, why read all this? Someone may ask for an adjournment. So that type of attitude on the part of the lawyers and the judges delays cases. Now it's not as if cases are not disposed of in good time, but the cases which are cited before you, about which we keep talking, are the cases which have not been heard. And if you pick up see the records of those cases, you will find that matter has been getting adjourned every day, every time it is stayed for it. And I'll tell you from my personal experience that there was a matter where I just was going through the order sheet, and I found that the matter had been adjourned 12 times on the same ground that the advocate is unwell. So when the matter was called out, looked at, I was no one there, someone came to mention that Mr. So and so is unwell, you lost Mr. kindly adjourn the matter. I said, this is very easy and right. He said, only yesterday night something happened, this doctor said, I didn't know to come before. So I said, what happened? I gave him an earlier date. That date also he was unwell. He said, I could tell you about that date, I was not here. I said, no, but it has happened on 11 earlier occasions. Same thing. He said, look, don't ask me more questions. I've been asked to ask for an adjournment. He will not say, grant it, because I will refuse. So I said, I'm not granting this. I'm going to dismiss this matter. Walks in a lawyer. He said, I will argue the matter. I said, who are you? He gave me his name. I said, but you're not well. क्या करेंगे? एडजर्न नहीं करते तो करना पड़ेगा. Now, if that be the type of attitude of lawyers, I don't think disposals can go up. Other thing is, these learned arguments, sometimes they run into hours and days and weeks. If we could cut short these arguments, we can do more cases. And it is not necessary. We are talking about arbitrations. Thanks to this technique, modern techniques that we have evolved, you can get papers on the tip of the finger, you can file case law, you can prepare briefs easily. Earlier they had to type, therefore they took some time and energy. Now it doesn't take all that time. You can dictate, some machine will type it, some machine will print it, and your brief is ready. There was a matter in which, as an arbitrator, I was waiting for the records to come, the records came. It came in an Omni, a small bag, and he started downloading. So, 23 bags of paper. Later I found out that the only thing good about those 23 bags were the bags themselves. The bags were very good. But the papers that were given to us, all useless papers which no one will look into. In that case, and the advocates also knew it. And not to be outdone, the other side also filed about 20 or odd bags. So our problem was where to keep the briefs, and even if you threw the briefs, where to keep the bags. They are good VIP bags which you like to throw away. So this is another tendency which I have noticed in arbitration. Arbitration law says, earlier it was 1 year for the arbitrators to do the law. Now it says that 1 year from the date on which the pleadings are completed. That means when the written statement or written reply or statement of defense is filed, you get 1 year's time to dispose of the arbitral case in that year. But then, I think in 80% cases, it's not possible. Because of these adjournments and all, long adjournments, some excuse is given. We also feel as arbitrators, all right, let us give him some time. High Court judges also know that these are the difficulties with the arbitration facing. So they are quite generous, liberal in granting time. And then that is one reason why even arbitrations can be there. Talking about arbitrators, you will find all sorts of arbitrators. Some who will be very generous in adjournment, some will be strict, some who are slow, some who are fast. So that is possible everywhere, in a court of law, in arbitrations, anywhere. But the effort should be to follow the timelines that the law provides. And if we are able to cut short on adjournments, cut short on long, useless arguments, perhaps we can move a little faster. That's all that I can tell to young people today, and to just for some other day. Thank you.
Thank you, sir, for your insightful address, especially emphasizing the need to develop the art of listening and respecting one's opponent. As we continue on this remarkable gathering, it is now time to welcome our chief guest, a visionary leader whose contributions to the legal landscape have been truly transformative. It is my privilege to introduce an esteemed legal luminary, Honorable Mr. Justice Muhammad Mustaq, a distinguished judge of the Kerala High Court. Justice Mustaq's judicial journey began with his appointment as an additional judge of the Kerala High Court in 2014, followed by his confirmation in 2016. He has also served as an acting Chief Justice of the Kerala High Court. His vast experience extends beyond the courtroom. He has been a mediator at the Kerala Mediation Centre, a faculty member for mediation training, and a panel arbitrator at prestigious institutions such as ICATR and the Indian Institution of Arbitration and Mediation. Born in Kerala, his illustrious career stands as a testament to his unwavering commitment to the legal profession and the pursuit of justice. Let's extend a warm welcome to Honorable Mr. Justice Muhammad Mustaq. Welcome.
I'm a batsman the last over. My previous batsman batted well, so either I had to go for a six or boundary, otherwise he won't accept. Honorable VP Singh, really, Vice Chancellor of Kerala. It is fantastic to be here. But watching the discussions of Lalit Pass, as in a VP Singh initiative on the duties and responsibility of a lawyer, whether they should have advise a client to file a case if they find there is nothing. But it has been, a different view has been expressed by Justice PPC that will depend upon how the cat moves from one side to the other. But today's generation, I don't think will have a much difficulty, but we will seek help of deep seek. So you'll get a certain opinion that if you go to someone else, the judge X, they'll get this verdict, and if you go to Y judge, they'll give it this verdict. So it may not be a much problem for you. Well, the moment I came here, I was thinking whether genetic science have done such a way that it's possible to reverse my age to enroll to LLB program here. We were enjoying such an enormous environment, the kind of the building, the facilities here is much better than a five-star hotel. But the moment the students stood up in their elections making their submission, they also made me realize, made me to go back and think about my school days and college days, where we are far ahead of our time. We generation did not have that much of facilities and enjoyment. That brings my memory when I heard or read somewhere, Senior Counsel Arvind Datta, you might be knowing him, one of the constitutional experts based in Madras and practice in Supreme Court. He was a student of Government Law College, Madras, in the Ambedkar Law College. So he had to take part in a moot court competition which took place in, I think, in Chandigarh. So college agreed to bear the cost of whatever the expenses, vehicle and training, or maybe possibly training. So after taking part in the moot court competition, he asked the college to reimburse 600 rupees. College refused to reimburse. So he filed a small court suit in Madras that I remember I heard or read somewhere. But see that those days how the colleges promoted moot court competition, what was their attitude? Where are we now? You have all facilities, best infrastructure, best faculty, But where are we now? Are you contributing same manner to the society? That's a big challenge. That's a big question for all of us. I can say no. With all these facilities, you are not giving back to the society and country. We have to go back in history and find out how this legal professions evolved through the centuries. When we spoke about arbitrations, India is, I think, the first in the world. The Bharat was the first in the world to recognize arbitration as a mode of dispute resolution. Way back in 1793, Bengal regulation, they recognized, British recognized our system. And where are we with arbitration today? We are still struggling. Lalit Pasna speaking about what is the conditions of arbitration in India. Where are we now? Today, this arbitration, it follows, it's imposed by super body as a part of UNESCO initiative. But for that, we would not have achieved anything. What is lacking in India? And that's where the challenge for all of us. How are we going to address these challenges? Every civilization, every society faces challenges. They're fraught with many challenges. They try to define justice system. If you look at the prayer from the Greeks, or they try to define justice. It is not a bit organized city of the city-states. They try to convey what is the meaning of justice. Followed by Abrahamic religion trying to see that they try to define justice as in terms of the intentions of the God Almighty. We have a different system in India. Of course, what we know, what we follow as dharma cannot be equated with modern concept of justice still. It defined human relationships. What is right and wrong. After collapse of Roman, in 16th century onwards, the rationalist thinking tried to define the principles of moral reasoning. What is a right or wrong? So today's most of the constitution and the civilized countries follow that ideas rooted from 17th century in Europe. But we still struggle to find justice, and we still trying to fix things which we now face in this world. Why? What is happening with us? So obviously, largely, it is because of attitude of the legal professionals, I would say. If you look at the constitution, post-constitution, it is the lawyers define this country's destiny. It is because of lawyers' role to define constitutional principles in terms of the need of the time. And that's exactly important. But for the lawyer's contribution, would not have constitution would not have remained as such now intact. Would have been destroyed long back. An attempt has been made several times. Changes pattern, basic structure of the constitution. But because of the interpretations put forward, the Supreme Court, accepted the Supreme Court, the constitution still remains a document could not be touched by the parliament. Why? Because of commitment of the legal professionals, society and nation. Our nobility comes from that idea, not from what we wear as a gown, a coat, a band, but for our commitment to the society and nation. So lawyers forgo their role and responsibility. That is a larger role issue. Whether you have a pendency of 5 crores and 6 crores or 3 crores, doesn't matter for all of us. If lawyers want to stick to their commitment to society and the nation, they can make a lot of difference to this process. So we are losing ourselves. Our identity is obliterated by passage of time. Today we have fought with another challenge. Either we have our relationship is governed by laws which would apply in a physical sense within the human or human instinct. But slowly, machine is taking over, but dominating our life. The machines we make will make us, and they define our relationships. So where are we now? How are we going to respond to those challenges when machines take over us? Are we competent enough to face these challenges? How to define justice in this process? Every country is struggling now, but that is the reason exactly our Prime Minister took part in the AA conference in Paris last week. Where are we going to face? Where are we heading? The struggle is not finished. Struggle is yet to begin for us. As I said earlier, every society faces challenges. They try to fix the issues, defining justice, which is quite appropriate to that time. But today we are not able to define justice except in the formal sense, as though the court expressing it through a dispute is the justice. And we identify synonymous with the court's declaration of non-justice. That is not the justice. If it can't impact on the life of the ordinary man, it can't impact on the life of the people living in the society, it can't impact on the life of the people living in this country, there is no justice. Our government, our preamble proclaim our justice, but that has not touched upon the life of many. So my youngsters, you have an honest responsibility. You may, the moment you step out from the law schools, you may tread the beaten path. If you tend to stereotype, I don't think you cannot make any differences. There is enormous possibility for youngsters. Whether using the advancement made by the technology or otherwise, there is immense potential for it. But to understand that potential, you also need to define your role. You need to create a space for you. That will make a difference in life. The past, we made all this difference because of our knowledge, our understanding of society. And knowledge considered so powerful for all of us. But today also, knowledge comes in a different way for us as an information, but we, for some reason, I believe that those information itself is a knowledge. On a click of a button, you'll get everything. That's only information. There's vast difference between knowledge and information. Because you all need not to browse books, read books and volumes. You'll get all the information at your fingertip. But you cannot survive the future with that kind of knowledge or information. The future belongs to those generations who are able to generate ideas. Society belongs to those who are competent or capable to generate ideas. It is not that what exists in this world, you can simply go and tap it. It's possible for everyone. It's like anyone. Whatever exists in this, with your knowledge or limited, you can go and tap it. But your responsibility in the future would all depend on how competent you are in generating ideas. And that will bring changes. You see, in every aspect of our life, the process itself fixes the relationship. You may not require a passport in the world because technology has reached the level of that level to recognize your face and find out what are you, what you were doing before any criminal case was not. So you can look at that. The process is now being calibrated through technology. That will create an impact in different aspects of our life. That means our traditional understanding of justice will slowly wither away from the courtrooms. And the process itself will emancipate and bring solutions to the people. Because of disconnect, otherwise, with the mainstream society and the system, these people will not get justice. So maybe tomorrow you'll be known as a specialist called blockchain lawyers or artificial intelligence lawyers, which more on the which focus on the process. We don't know what is the classification. But what I request you, your space in the future all depend on how good you are in generating ideas. We generation is not in a position to guide you. We were guided in past by our older generation. So we could withstand because we just go their path. But your generation cannot find such guidance from your predecessors and others. You will have to make your own role in the space. The law schools and the university have a limited role in shaping your life. It is you to make a way for you. And you have to define your role and find the space. I'm sure that the kind of program, kind of engagement will elevate your thought process. With all these words, I conclude. Thank you, one and all. Jai Hind.